Hi, this is Attorney Mike Gravel coming to you from Chicago as usual, and today I've got another fun one. It's a pseudo lawyer. You can thank Brett for this. He sent me down this rabbit hole in the comments, and yes, it is, in fact, deliciously awful. Also, I stepped on my Russian introduction, so we're going to give you the full bit here. Let's do it.
Hi, I'm Kat. Добро пожаловать. Закон с Майком. See ya.
Have you ever seen Let's Talk with Mike?
Yeah, many times. We can.
Well, hello, my friends and fellow investigators with the
Hello.
NATF.
What is this NATF? I thought you would never ask. Why, it's the National Action Task Force, and it is deliciously awful.
I want to just take a brief moment to go over the options that you have as the final step for your notice and demand. Okay?
You have none. This is really fun. It's a guy just spewing his stuff. Reminds me of Ryan Alt and all the other pseudo lawyers. Kirk Pendergrass, Russell J. Gould, Anthony Williams.
A number of our members have been sending out notices with demands
Oh boy.
to their fellow public servants. And unfortunately, some of those have been ignored and our public servants have defaulted. Therefore,
Yeah, of course they've been ignored because nobody cares because it has no force.
acquiescing to the charges that are being levied against them as damages for trespass. Okay? So let's just
It's funny, the sovereign citizens really get upset when other people don't consent. And these people categorically do not consent to your jurisdiction because you have none.
review the general process here real quick. We first send the notice and demand. It's a friendly letter saying, hey, Bob.
Just by the title, notice and demand, it's not a friendly letter. It's crazy, it's pointless, but it's not friendly.
Bob, I know you will sometimes act as governor. I want to let you know that you're doing some things wrong here.
Well, thank you.
X, Y, and Z are unauthorized. You do not have authority. Therefore, there's no lawful basis for it. And in the process of doing so, you're violating my rights, which you've taken an oath to uphold the Constitution and sworn to protect those rights. I'm only seeking remedy. The remedy is you stop doing what you're doing and take corrective action. If you don't do that, then it's a willful trespass upon my rights. And here's what I charge for those types of trespasses. All right. So
Again, it's back to the woman who wanted $300,000 to pull over with all the cops chasing her. Just okay, just make up your own thing and then say you're charging people.
either correct your unlawful behavior or pay for the damages you're causing. Okay. So that goes out. That's the notice and demand. You give him 10 days to respond with full notice that if he fails to respond and show good faith in correcting his actions and bringing remedy to the situation, then he's acquiescing to the...
No, he's not. It's just you don't have the authority to do what you're doing, and it will be summarily ignored. In the unlikely event that someone did respond and just said, hey, pound sand, I don't agree with what's your plan then? First of all, this is all dopey, but they just run on the assumption that they have the equivalent of a default judgment every time. Well, if anyone could take them seriously, they would respond and say, no, I disagree. And then you would have a hearing and these people would lose because there's no merit.
facts that you are stating. And now it's a willful violation which could possibly bring criminal charges.
No, it couldn't.
Okay, but we're not interested in criminal. We just want the civil. So he defaults. You send him a notice of default absolute.
Ooh,
and
absolute.
With that, you send a final invoice.
That's like an affidavit of truth.
Right? You sent the invoice payable within 7 days upon receipt or whatever. He fails to pay the invoice, you send a late notice. Please pay. Here are the instructions. This is the invoice. These are the payment instructions. He fails to pay. He's now in default and dishonor.
Default and dishonor. They just make this stuff up. It's not, there's no law behind any of this. I mean, the word default is used in the law. Dishonor, I suppose, in some context, but it makes no sense here.
You by his silence. All right. So that's the process. And you know that already. Just wanted to review that. So now what's the next step? How do we collect? All right. Now there's.
Oh, yeah. Everyone's familiar with this bogus process that's never worked once in the history of civilization. Don't forget to hit like and subscribe if you like the way that Oscar waddles.
There's 3 options that we have. One, you can take it into county court and request a summary judgment. Some people may not be real comfortable with that because they're not familiar with the courtroom.
Yeah, because there's no basis to ask for summary judgment based on this nonsense that you've described so far. Okay.
So much. All right. There's 2 ways you can do it. You can do it as a legal person. You can do it, secondly, in your court in common law. And the beautiful thing about common law is anybody can do it. It's simple. It's very simple. But you can't let them trap you into stepping over that line from common law into their statutory world, where the judge then becomes a judicial officer instead of a magistrate, merely coordinating your court. All right. So
they're judges. Regardless of your actions, judges are judges. They're elected or appointed, and that's the position they have. It is not predicated upon your actions. They are, whether you bring an action, don't bring an action, whatever. That is the situation.
So if you go that route, you really need to take the course, the law common to I. All right.
Oh, no.
Lorna has put up some promos on that. And I'll be putting up transcripts of the courses that I took. I went through the course. There's like 5 sessions. I'll be putting up the transcripts of that in our self-governance and common law course. Actually, it's going to go in the legal defense channel, which is bundled with the self-governance course. Okay. So that'll be up there. And I suggest you study that.
I suggest you don't. If you'd like to stay out of jail and not be laughed at.
Convene your court in common law. File it with the...
Oh, wait. You're convening your own court now? We're doing the postal court thing? Okay.
The county court clerk. Use their building for your court.
Wait a second. You got your own court. Why are you involving the court, the county court? Probably because you know you have zero legitimacy and you're trying to use that.
All right. Now, there's a third option, and this is the quick and easy way. All right. The third option means you're not going to get, millions of dollars in damages.
Oh, no.
Whatever the larger amounts are that you've been invoicing. All right. But
you're not going to get anything.
What you do is you take it to small claims court. Each state has a maximum allowable claim in their small claims. Okay. So look that up in the statutes. What is, look up small claims court, learn all about it. What's the maximum amount you can claim? Go in with your invoice for, $250,000. All right. And file your claim for $25,000. The beautiful thing about...
By the way, that's more than most small claims courts by a wide margin. And this whole idea is horrible, but it just shows to me that he hasn't even looked it up where he is.
Small claims is that it's the closest thing to common law that there is. Okay, you don't need an attorney. You
don't need an attorney if you're bringing an action on your own behalf for anything. He doesn't even appreciate that. That's the one thing he's saying. Oh, well, you can represent yourself pro se in small claims court. You can represent yourself pro se in any court, really. In Cook County, with the exception of you can't represent a corporation, but that's not yourself. That's a corporation.
File your claim, file the case, state your claim. When the case is called, you present your documents, you explain what you did, you verify that service was properly handled.
And then you wait for the judge to stop laughing.
That he did receive those, and you've got proof of service with your certified return receipt cards, and you've given him notice, you've acted in good faith, you've given him late notices, all right, and you've gone through the whole process.
It just shows right here he's trying to do this, and some of this stuff sort of makes sense. He doesn't understand anything about law on any level. It's all wrong. He's acting as if you have to do some follow-up notices. The procedure is pretty much universal. You get service on your opponent. You would usually effectuate service not through certified mail, although that is possible. That's not the usual way. You usually get them served through the sheriff or a process server. And then if they don't show up and you have proof of service, you can ask for a default judgment at that point. You don't need to show good faith in the interim or additional things like he's saying. And he's just running off at the mouth because he knows nothing.
And he's failed to respond. All right. You've completed the process. It's correct. The judge needs to give.
Wait, who said it was correct? Nothing about this is correct, but I just love it. Again, the self-affirming, soothing as he goes.
You an award for the amount of your claim, which is $25,000.
No, they don't.
Okay. Now, that's not going to make you rich, but that's not the objective here. You will get some.
That's a good thing. It's not going to make you rich. You're not going to get a judgment. If you got a judgment, you're not going to collect on it. But okay, carry on.
Cash flow out of it, and praise God for that. That's a beautiful thing. You know, if you can get $15,000, $20,000, $25,000, that would really be a nice little bonus, wouldn't it?
That has never happened in the history of this procedure. Make up a claim, bamboozle a judge into it. Somebody might have gotten to the point of getting a default judgment because somebody blew them off. That's plausible. If they actually came after them to pay it, they'd say, "Well, hell no," and they'd get the judgment vacated and say there was no basis for it. That's what would happen.
But think of this. Think if we had dozens and dozens of people who are doing the same thing and hauling the governor, hauling the director of the state health department, hauling the sheriff, hauling the judge.
All of these people have immunity, by the way. It wouldn't work against a private citizen either, but in his little fantasy here, he's going after public officials. It's like there is no way.
Judge, whoever, into small claims.
Oh,
and
yeah.
The claim isn't against the judge or the sheriff. It's against Bob Hall, who lives on Main Street.
Yeah, that's cute. You said the basis of the claim was that them not acting in their official capacity correctly. So, but now you want to sue them as an individual. I mean, it's just one of 6 million problems, but it's so wrong on every level.
Who also sometimes acts as the judge or the sheriff. So you're not suing the title. You're going after the man in common law. And you can do that because he wasn't authorized to be doing what he was doing. And so he does not have that title. He does not have sovereign immunity, judicial immunity, or any other form of immunity.
Again, he just doesn't get it. Your theory of recovery is that somebody breached their duty as a public official. And, you know, if that's your theory of recovery, then all of their tort immunity and all that stuff would come in, qualified immunity and those sorts of things. Number one. Number two, even if you were doing a private citizen, take office holders out of this and you were doing this to the local bartender, say, you don't have any basis for your claim. It's a loser. You're going to fail.
So let's do this. Let's get as many people as we can filing against the same individual, all right, and have them spending all their time showing up in small claims court.
Yes, this is just straight up illegal harassment. I mean, that's all this is. And he's proposing it loud and proud on his YouTube channel.
Getting hammered. Now, the other alternative is if you want to go to county court, chances are that case you could file the the claim, and that case might not come up on the docket for possibly 2 or 3 months. Now, in the meantime, as long as that case is pending, you can file a lis pendens lien on the assets of that individual to freeze his assets until the court has made a determination, and that's perfectly legal. You can also file public notices that a claim has.
Technically, you can file such things, but there's no underlying basis for these claims. It's all a sham, and you're going to end up probably either with sanctions and or maybe even criminal liability, because there's no basis for the things that you're doing.
It's been made against Governor Walz for $2.5 million. Anybody who would contest this claim can respond at this address. You file that in the legal notices in the newspaper. All right, that goes out to all the credit bureaus. So, regardless,
none of this will work, but you can harass people in the meantime because people don't know if it's legitimate or not because you filed things. So you can do a little bit of this. Eventually, you get sanctioned because there's nothing in there, and if you persist with it, you'll get charged.
Because of what happens in the courtroom for 2 or 3 months, you can really play with their minds in screwing up their credit, and just that alone will get their attention. And just think, if they get one of these, then another, then another, then another, think about the effect that will have. Do you think you might get their attention?
And here's a classic example of why attorneys are licensed. We actually could do this and do this effectively. We would also get our licenses pulled for such a maneuver. So this just straight up using the court process as harassment is does not lead to good places. Now, he doesn't have the fear of losing a license because he's not licensed, and hell, he doesn't even know anything about the law. But and he's also not worried about a judgment on him. But if you persist with these things far enough, he'll find some trouble. You can get yourself in jail over this if you try hard enough.
All right. You think you might possibly get some corrective action? Different ways you can go with that. But anybody can do this.
Anybody can drink and drive, too. It doesn't make it a good idea.
Our legal team would be more than happy to perhaps provide a little coaching.
Oh, his legal team. There's not a licensed attorney in sight. It's just a bunch of Anthony Williams and people making up their own laws, just deciding whatever they want to do. I'd love to see the legal team in action. I really would.
For you on that in relation to court filings and so forth. So let's do it. That notice and demand is extremely powerful. We have to put it to work, and we have to seal the deal. Okay? That's the most potent weapon we have in America.
Capital felony treason.
Get this out to people, and once we start getting a couple successes,
once we start getting a couple successes, implicit in that is they've never had any before, because they haven't, and they will have none in the future as well. Oh, it's too good.
It's going to be Katie bar the door, and we will have a national impact once word starts getting out as to what you are doing with your notice and demand. Okay, so we can talk further about this in the forum, but I wanted to share this with you and get you on track. So I know a lot of you have been waiting, and I apologize for the delay in getting this information out to you. So there you have it. All right, let's get busy. Take care. God bless. Hope to see you soon.
Oh, well, there you have it. I don't even know this guy's name, but his outfit's called the National Action Task Force. It's fantastic. It's right in line with Bear's Law. And of course, Russell's Postal Court. It's also fun. Sometimes I've been doing a lot of real court hearings, and that's fun, and those are interesting. But this hit just the right spot where I wanted to go to Wacky Land and have a little fun. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.